And I think we can begin. Thank you very much. Welcome to our third in the series of child custody, child maintenance and divorce webinars, whereby you can register, you may register, and when you register you pose a question and we will deal with those specific questions. There have been many people who have registered for this specific webinar, quite a lot, and we had to set up 2 Zoom links, so I'm keeping an eye on the 1 Zoom link. There are fewer people on this one, however the next Zoom link is on the other screen, and if there are any questions being posed on that specific Zoom link, I shall obviously deal with both at the same time. But nonetheless, welcome. If you have a question, it can be dealt with as follows. If you are on the live Zoom link, you're welcome to put up your hand and I can unmute you. And obviously you can communicate with me and engage with me and we can deal with that specific question. The other way is obviously to type the question in the Zoom and we can communicate that way. Those are the 2 ways, and via the Facebook Live, you're welcome to leave a comment on the Advocate Mohammed Abdullah Facebook page. And based upon that, we can engage and we can deal with the specific issues. There has been a total of, I think, let me see, 14 questions that were posed by registrants, and quite a lot this week. Many of the people that register do not necessarily join the Zoom link. They wait for the video to be published a day or 2 later. And in that video, of course, I would have dealt with your specific legal question. And many people, they just go on Facebook Live the evening and they watch it. But remember, this is live, so if you have a question and you pose it later on, I will obviously not see it immediately and maybe not deal with it as well, because we're busy with the next webinar the next day, and that's how it goes. Nonetheless, welcome again, and let me deal with today's topic: child custody, child maintenance and divorce, part 3. I'm just moving the screen a bit out of the way so I cannot see the other people who are also on this webinar. The first question that was posed, let me deal with that. Question number 1. From the Western Cape, my province. If someone was garnish and the company failed to do what the court order says, been the court numerous times, still trying just call and take no action towards the company, what do I do? Remember, I copy and paste the questions as they are provided. So basically, a garnish order was granted, and what's happening here is the other party, or maybe the employer in the specific case, does not comply with the specific garnish order requirements. Let me move that out of the way. Some issue we have regarding this. Nonetheless, what happens then? What happens then? What do you do? If you applied for maintenance, for child maintenance, you've done what you had to do. Nonetheless, unfortunately, the court is not here to assist you much, and here you approach them again and they issue a garnish order, but nonetheless the garnish order is basically useless. Basically what I'm saying is, let me just fix this quickly. My apologies for this. I need to fix the screen properly, otherwise we will have major problems going forward. And let's do a proper job here. Move it up. I think that's much better. Put that over there. Sorry about this technical stuff I have to deal with today. It's one of those strange things that happens if you have more than one Zoom platform to deal with. Okay, let's move on. So the mother applied to the maintenance court for maintenance order. She obtains the maintenance order. The father, in the specific scenario, might not be paying the maintenance on time. She goes to the maintenance court and lays a complaint for non-compliance with the maintenance order. The court now issues a garnish order against the employer. The garnish order gets served upon the employer, and the employer basically does nothing regarding that. What happens then? What can a person do under those specific circumstances? Okay, now firstly, the person or the organization that's at fault here would obviously be the employer, because the employer has a legal obligation to execute a garnish order. In terms of the Maintenance Act and the law, it's a criminal offense not to comply with the garnish order on the part of the employer. Therefore, my advice to you is to go to the maintenance court again and lay a further complaint against the against the employer. Explain to the maintenance court, you approach the maintenance court initially, and what's happening now basically is you obtain the maintenance order, it's useless. What's the use? You approach a maintenance court initially, obtain an order, and now you get served upon the employer. The employer has the money, the employer is able to pay the maintenance directly to you, but they are not doing it. So what's the use? You approach a maintenance court in the first place. And what is the use that the court issued a garnish order against the employer? Complain to the senior magistrate, complain to somebody over there, because what has to happen over here is criminal action has to be taken against the employer. And unless you put some pressure on the maintenance court, nothing will really get done with that is concerned. So my advice to you is you need to action that. You need to start actively playing a part in the specific process. Make a noise until somebody does something and pay you the maintenance which you are entitled to. It is obviously, as I mentioned earlier, a criminal offense not to comply with maintenance orders. Okay, here we're dealing with question number 2 from Gauteng. My daughter is a respondent in a children's court matter. She requested access to the court file and was granted access. The clerk says she can only give it to her lawyer, but she hasn't won. And that's a problem I also have. I've appeared in the children's court recently, and I requested the court file, and my client lives quite close to the children's court. My apologies for that. And I requested it. I made a formal request. The magistrate authorized me to obtain the documentation. To save fees, I asked the clerk, would it be fine if my client can go and collect the documentation dropped by my office? COVID-19, title limit movement and unnecessary approaching courts. The clerk of the court said, no, I must attend. I could not see the logic behind that. It's my client. The documentation is basically for her to apply to her case. Tomorrow, should anything happen, and let's say for argument's sake I withdraw from the matter, or she obtains another lawyer, whatever the case may be, then of course she'll get hold of this documentation. I cannot see the logic behind why a lawyer should specifically receive those specific documents. There's no logic behind it. And in terms of the regulations, it doesn't make sense. It doesn't specifically stipulate that the lawyer is the only one entitled to, but not the client, because the client is the one dealing with this matter. I can understand potentially if the client has an attorney. Yes, maybe under those circumstances it makes sense. Let the attorney deal with the court. But in this specific scenario where the client is representing herself, I see no logic behind why the client cannot on her own collect the relevant documentation from the children's court. So I cannot see any logic behind that. You obviously need to complain. Maybe write a letter to the magistrate advising the magistrate, I am representing myself in a specific matter. I require a copy of the court file to know exactly what it is so I can properly be prepared for court. Please allow me access to the court file. I do not have an attorney. That should most probably fix the problem at hand. Okay, that was question 2 from Gauteng. Question number 3 from the Eastern Cape. Please note, before I deal with that, if you are on the Zoom or on Facebook Live, you're welcome to engage with me on the Zoom. Put up your hand and I will call you in, and we can chat to each other via this line. Or you can type in a specific question in the chat box in the Zoom, and obviously on the Facebook Live you can type out whatever you like to type it, and I will deal with that. Question number 3. Must I wait 10 days before I can obtain a date for an unopposed divorce? We entered into a settlement agreement and I want to go back home. So if I read in between the lines, the parties are involved in divorce proceedings. They signed everything. The documentation was now served upon the other party. Now the law says that 10 days has to elapse. My apologies for that sound in the background. It's not in our building. There's a lot of renovations taking place here in Cape Town. So you might use some background noise. My apologies for that. I have no power over that. Okay, let me get back to that. My apologies for that. So 10 days should expire before the party can approach the court to obtain a court date for the unopposed divorce. Here we do not want to wait for the 10 days. Here we want to get divorced as soon as possible. Some judges does not mind if one of the parties provides a waiver. So remember, you as a defendant, you have a right to allow 10 days to first expire for you to think about whether or not you are defending the divorce or not. So in your specific scenario, you are in agreement with the divorce. The plaintiff issued the divorce, served it upon you, and you signed a consent paper and everything is ready to go. However, why must you wait 10 days? Why can't we just proceed with the divorce? So if you want to, you can provide a waiver, a document stipulating that I waive my right to for the 10 days to first expire, and the divorce can proceed nonetheless. An affidavit might be a good idea as well, but it all depends upon the judge on the day. Some judges are okay with it, and some judge might have some issues with that. But the waiver would be the way forward to do that. So that was question number 3 from the Eastern Cape. Thank you for that. Very interesting question. Question number 4. Please let me know what is economical abuse in a domestic violence setting. Okay, interesting question. My husband is living with this new girlfriend, I presume, and does not want to rent. He has been doing so for the last 2 years. Okay, so I presume the husband got a new girlfriend and he does not want to pay the rent. That's basically what's happening over here. Now, in South African law, if you are the provider of your spouse, you obviously have a legal obligation to maintain your spouse. Now you are using money, economic, to abuse a spouse. So, for example, the spouse needs to pay his rent or her rent, and what you are doing now is you are now saying, no, I'm not paying the rent. So you're causing a bit of issues over there. So you're using money to abuse the other party, like psychological abuse, emotional abuse. You're using financial abuse. Under those circumstances, it is domestic violence, and the court may order that you should pay emergency money relief because you are involved in economical abuse under the circumstances. That is economical abuse taking place. What we are dealing here with. So, for example, let's say you have a husband, he earns a living, he earns a salary, etc. The wife is at home, she cooks, cleans, irons the shirts, and so on. And all of a sudden, the parties separate. What the husband does is, no, I'm not paying you anything. Yes, the wife can go to the maintenance court, of course, but that might be a long procedure. But what it's actually doing is trying to abuse her. That's where economical abuse kicks in. So I hope that answers the question. You can go to the domestic violence court and ask for emergency monetary relief, where the court can order that the other party immediately pay you a sum of money. Question 5 from the Northwest. If my child is 17 years old, can she decide with whom she wants to live with? We are divorced and the divorce order says she must live with a mother. However, she now wants to move in with me. Okay, 17 years old, the child will soon be an adult. Quite interesting. Now the child wants to live with the dad, although the divorce order says the child must live with the mother. Unfortunately, the child is 17 years old. She's still a minor. She cannot decide on her own where she wants to live. She's still under the care of her parents. The parents will have to decide what's best for her. Under these circumstances, it might be advisable, depending upon how old the child is. If the child is turning 18 in a month or two time, best to maybe just wait it out for 2 months and the child can decide then. If the child turns 17 now and circumstances would obviously prefer that the minor child immediately lives with the dad, then unfortunately the father would have to approach the court to have the court order which allows the mother primary care to be changed to allow him to have primary care. So that will obviously deal with that specific issue. So follow the court order. If the parties are not willing to amend the court order, or not amend it necessarily, act differently towards it. For example, the order says that the mother should have custody, but the parties can agree that the father should have custody until the child turns 18 years old. Okay. If the parties can't come to that agreement, unfortunately the father would have to approach a court. Otherwise, he will be in contempt of court. Question number 6 from Gauteng. I'm just keeping an eye on the various platforms. Yes, I have a question here from the other Zoom platform, not the one that's online, the one that's more full. I have a colleague here next to dealing with that specific Zoom platform, allowing people into that one. Yes, I have a question regarding that. It refers to the 10 days. Yes, question number 3 from the Eastern Cape. Let me deal with that quickly before I go to the next question. The question is, can my spouse email the court telling the court that she is fine with allowing the divorce to proceed before the 10 days expire. Okay, that's a bit of a difficult one to answer, because email, who do you email? Do you email the judge? Do you email the clerk? The proper procedure with these type of matters are that you need to file documentation at court. So basically what will happen here is the one party will file or set down the divorce before the expiration of the 10 days. And then that party will obviously hand into the court on that specific day and advise the court, or file it before the time that the other party waived his or her right to the 10 days being expired. So that's basically the practical way on how it will work. If that will be done via email, so you'll email the other party's lawyer, the plaintiff's lawyer, advising the lawyer that you are waiving your right to the 10 days. Fine, you're welcome to do that. And obviously that attorney will file the documentation to court when before the matter gets heard. The judge will read the documentation and see, okay, I see 10 days hasn't expired, but I see a waiver email. So that could possibly be okay to do. Nonetheless, it will all depend upon the court and what the court attitude under the circumstances. Okay, I think we've done well where that is concerned. If you have any further questions, feel free to pose it. Let's deal with question number 6 from Gauteng. I'm just checking the chats out quickly before I proceed again. And the Facebook Live, please note you have to go to the Advocate Muhammad Abdullah Facebook on Facebook Live if you want to pose a question. Question number 6. Thank you, Advocate, for your time. You are welcome. My question relates to relocation. I plan on getting married to someone who lives in the United States. I have a child with my ex-husband. How do I go about it if I want to take the child with to live in the States? She is 5 years old. The father pays child support and sees her every second weekend. Ooh, difficult one here. This relocation matters are challenging because firstly, you're dealing with a one situation whereby the party needs to go overseas to continue living his or her life. Generally, the primary caregiver. I'm dealing with that scenario. Like in our case here, with our Pacific questioner here, she wants to go to the United States to get married and obviously move on with her life. But she needs to take the child with her because she's a primary caregiver and the child is 5 years old. But should that happen, it will affect the other parents' rights of care and contact in South Africa, because the parties are moving into different provinces where they can visit each other once every few months or now and again, or different suburbs where they can have contact, continue having contact every second weekend here. Basically, the father in this specific case might only see the child once a year or every second year, and obviously via Zoom and WhatsApp video and so on as well, but the physical contact won't take place anymore. However, the law says in every matter concerning the child's best interest is of paramount importance. Therefore, if you can convince the court that considering all the factors, considering that the child will no longer see the dad as the child is used to every second weekend, and so on, it will be best for the child to relocate with you to the United States. The court will obviously grant such an order. You will need to convince the court, firstly, that life in the United States, firstly, will be better for the minor child. There are schools available, there are educational places, there are medical facilities. You will be able to care for the child. Yes, you say you plan on getting married, but what if the marriage doesn't work out? What happens to you in the United States? And so on. So you need to paint a picture to the court that, all avenues have been, considered, and you apply the mind to it. And it will be best for the minor child to relocate. And the other option, of course, is you can't leave the minor child behind here and you go to the United States. And where will the child be cared for? Can the other parent care for the child? And will that be in the child's best interest? So it's one of those type of questions whereby you have to apply logic, common sense, and and you have to look at the matter pragmatically here. Should I leave the child behind with the dad? But the dad never cared for the child. But would that be better for the child? The child is 5 years old. The child not attending school as such per se. The child can start school in the United States. So that's my advice to you. So apply your mind to the matter. See if it is best for the minor child to relocate with you. And of course, the child will have to go with you. But try to find information and data that will obviously convince the court that it will not make logical sense for the child to stay behind or for you to remain behind. under the circumstances. So that was question number 6. If you have any additional questions, feel free to pose it. I'll be keeping an eye on both chats. I see some questions have come in now in the chat. I will deal with that a bit later on. Question number 7. Why must a father be present if I want to apply for a passport for my child? He never visits the child and pays very little child support. His name is also not on the birth certificate. Thank you. So what's happening over here is the mother would like to apply for a passport for the minor child. She went to the Department of Home Affairs and said, here's my child, here's a birth certificate. I would like my child to obtain a passport. What happened then was the Department of Home Affairs said, no, we want the father's details. No, the father lives somewhere else. He's not much involved in the child's life. They said, no, nonetheless, we want the father to be present here to give consent for the minor child to obtain a passport. That's what they are what they are saying. Now, there are many reasons why that could be the requirement. Firstly, the legal requirement would be in terms of the Children's Act, Section 18, specifically stipulating that both parents should consent for a passport. So that's fine. Both guardians. But sometimes it happens that the father is no longer a guardian because he was never involved in the child's life, or he abandoned the child and so on, or he never acquired any parental rights and responsibilities in relation to the minor child. But here we have a problem. Home Affairs wants it. Another reason could be parents could be lying. They most probably want to relocate, leave the country, and maybe indirectly abduct the minor child and limit contact between the minor child and another parent. Under those circumstances, Home Affairs is obviously concerned about that, kids being abducted, parents leaving the country, and therefore they want the involvement of both parents for the issuing of a passport for a minor child. That also makes logical sense. They do not want to form part of this. I have dealt in the past with a lot of scenarios where clients are coming to me now, advising me 5 years has passed. The minor child would like to renew his passport, but the Home Affairs is now adamant that the father should now be involved. I asked the question, how did you obtain the passport the first time? Then they advised me that Home Affairs did not ask where the father was, but now they are asking, and that seems to be the trend now happening. So if the father does not want to give consent, you would have to apply to the High Court, and the High Court would obviously have to give you consent for that. So that was question number 8. I have an additional question here regarding the relocation. Question number 6. It goes as follows. Thank you for that, advocate. You are welcome. The father said he will consent, but on condition that he pays no maintenance. Is that right? Okay. So here we have a scenario whereby the parties have discussed this matter. The father said he will consent to the minor child relocating with the mother to the United States, but as long as he pays no maintenance for the minor child. It's one of those things, you can decide, can you live without the maintenance? Do you need the maintenance in the United States? I do not want to tell you now, fight the maintenance, and now you'll have to approach a high court now to get consent, or for the court to dispense the father's consent for the relocation. However, if the father is willing to say that, because obviously the United States it's very expensive. I mean, it's dollars, and for the father to pay maintenance, South African rands converted to dollars might not be that much. And if you can most probably come to an agreement with the father and tell the father, okay, that's fine, give me the consent, I will not request maintenance from you, it won't be much in any event. However, we can act amicable and let me move on with my life, and I can afford not to obtain maintenance. That's up to you. I'm not saying you should do that or you should not do that. It's a decision which you will have to make with the father. Or maybe the father can say, I'm struggling now, and in the future, if you do require money, please contact me then. But for now, I think you're okay. So that's something you guys will have to work out. But if you are not happy with that, and if you think it's unfair, then of course, do not listen to the father. He should continue paying maintenance. And if he does not want to give consent, you approach the High Court, and obviously the High Court will determine what's best for the minor child. And you obviously stipulate in the court documentation that the father stipulated that he's willing to give consent, so he's fine with it in principle, but he does not want to pay maintenance, and the court can decide who is reasonable and who is not reasonable. Okay, we are doing very well in time over here. I'm trying to get done with all the questions before we start dealing with the live questions. If you have any questions on the Facebook Live, you're welcome to type it. Question number 8 from the Western Cape. There's a lot from the Western Cape and KwaZulu-Natal, I see, some from Gauteng. Why does the law only take the side of the father when it comes to child maintenance? The father is wealthy, but the courts does not listen to me. Very interesting question. And you know what? It depends upon the gender. Sometimes the father will contact me and ask me exactly the same question, but the difference is he will say, why does the law take the side of the mother? Yeah, a mother is contacting me and she asked me the question, why does the law take the side of the father? It depends what side of the fence you are, which court you are, which magistrate, the facts of your matter, etc. Nonetheless, I will obviously now have to answer that question. I do not necessarily say the court takes the side of any specific gender. The court will obviously have to look at all the facts. The court might have preconceived views and ideas on how matters should proceed. For example, if you're asking the court, the father should pay for a pony, the father should pay for expensive shoes and expensive cell phones, and now the court says, no, we don't think that's reasonable, and the father also does not want to pay it, and then you might have an idea, no, why is the court now taking the father's view? They should allow it because the father can theoretically afford it. So it all depends upon the facts and the circumstances. However, you also have other issues where certain courts believe that maintenance for a 5-year-old child must be so much, despite how much the parents earn, which I do not agree with. And these courts might have their preconceived views and ideas on how things should work. However, the long and the short of the matter is, if that specific court is acting improperly and giving an incorrect decision or unfair judgment under those specific circumstances, you are obviously welcome to challenge the decision and take it on appeal or review and so on. That's 12 o'clock on Noongan, if you heard that. So, long and the short of the matter is, I do not believe a court does have a specific preference in principle. You might find a specific magistrate for that specific case might seem to favor a certain party, and unfortunately it's you, but the law does not apply that specific way. But if the court makes an improper decision, you should take it further, either take it on appeal or review, whatever the case may be. Question number 9 from the Western Cape. Let me just have a look at the other WhatsApp, other Zoom. Looks fine. There are a few questions over there. I'll deal with it a bit later on. Please, if you do ask a follow-up question, just mention which question you are referring to. Question 1, 2, 3, 4, 5. Okay. Question number 9. Interesting question. Is it expensive to change your marriage from COP to ANC? Now, if you do not know family law, you'll think, what do you mean by COP? Is it a policeman? To ANC, is it a political party? Now, COP means community of property, and ANC means anti-nuptial contract. Obviously, it makes sense to me because those two terms are together, community of property and ANC, and we're dealing with family law, and marriage is in the mix as well, in the question. So this specific person is currently married in community of property, whereby what belongs to the husband also belongs to the wife. It's just one joint estate. So before they got married, there were two separate estates, but once they got married, there's one estate. So they came in with their debts, with their assets, whatever they had, it's all in one. If the husband does something, he is obviously buying the joint estate. If the wife does something, she's buying the joint estate as well. There's no separate estates any longer. Once, should they get divorced, they will have to divide that estate again later on. The husband cannot say, oh, but before the marriage I owned 10,000 rand, I want it back. No. That 10,000 rand and her 5,000 rand and her property and his car is all put in that pot once they got married, and then they have to divide it afterwards. So he can't get his car necessarily back. They can agree to that, but it will all form part of the pot. The question is it expensive? It is very expensive. Okay, expensive is a relative term, but I'll compare it to having married from the word go in community of property, out of community of property with an anti-nuptial contract. Let's say, for example, an anti-nuptial contract costs, for argument's sake, let's not be too conservative, 3,000 rand, because there are some funny clauses in there. And that's fine. So a month before the parties got married, they enter into an anti-nuptial contract stipulating that they are married out of community of property. What's his is his, what's hers is hers. And maybe with a cruel regime, that should they divorce, whatever growth there was in the various estates, they share equally where that is concerned. So they came to that type of an agreement and they entered into an anti-nuptial contract. It was signed before a notary public, a specialist attorney, and it was obviously registered within 90 days of signing, and they got married accordingly and so on. Done, 3,000 rand, well spent. They get the original back after a few weeks or whatever the case may be. Now, let's take it one step back. The parties did not invest in that amount of money, in that 3,000 rand for anti-nuptial contract. They decided to get married nonetheless. So they got married in community of property. Now, moving forward, they got married in community of property. 6 months later or a year later, oh, they said, oh my gosh, certain issues are happening over here. I now find out that my spouse has so much debt, or he is catching on nonsense, or she's catching on nonsense, or I would like to open up a business, but I see I'm at income to property and I might potentially affect the joint estate. So let us now slice this joint estate into two, divide the assets, and let's move on with our lives. For that, you require the consent of the High Court in the jurisdiction where you reside. So if you live in Gauteng, the Gauteng High Court, Western Cape High Court, and so on. So when you're talking about High Court, you're talking about attorneys, you're talking about advocates. Some attorneys can appear in the High Court. But you're speaking about lawyers. You're speaking about notification in the Government Gazette, in local newspapers, 2 local newspapers. So you're speaking money. That's where I'm going to. And also you have to serve the documentation on the Register of Deeds, and they'll have to give a report as well. So they also cost money and admin involved. Drafting of court documentation as well. An application must be drafted. You must also give notification to your creditors, Markhams, Edgars, whatever they are. Work involved. Government gazettes, newspapers are quite expensive. I think that's where the most of your money goes to, where the expenses are concerned. Obviously, an advocate will have to appear in court as well. An attorney will have to draft the documentation. Advocate might have to settle the document, whatever the case may be, and the documentation must be served. So it costs money. I do not want to put a figure to it, but I'll just give you a general amount, maybe 20, 30,000, depending upon the circumstance of the matter. That's what you're talking about, as opposed to the 2,000, 3,000 rand which you have spent before the marriage, should you have decided to enter into an anti-nuptial contract. So changing it afterwards can be very, very expensive. As I mentioned, expensive can be relative. Nonetheless, it will cost more money and a bit of hard work involved changing it afterwards. I have a question from Facebook Live. It goes as follows. Can you apply for child maintenance when you are married? Yes, you can. So if you obviously got married to your spouse and there's certain issues involved and your spouse is not supporting the minor children or the minor child, and you are welcome to go to the maintenance court nonetheless, even if there is no divorce in the future, in the horizon. You most probably love this person, you want to stay with this person, but this person is very stingy, this person doesn't contribute properly. You do not intend divorcing this person, but you want this person to pay maintenance. Yes, you can still approach the maintenance court, despite you being married and living in the same home. If you're living in separate homes, still same thing, same principle applies. So that's fine. I hope it answers your specific question. If you guys are planning on divorcing, and then obviously there might be a quicker procedure like in the High Court, a Rule 43 application for interim maintenance. But I hope that answers the question on the Facebook Live. If I have not, please feel free to comment further. Those questions which I have here on the Zoom, I will deal with that a bit later, so I can deal with all of them, and then we can go question 13, question 14, question 2, question 3. Question number 10 for now. The question that was posed previously when the people registered for this webinar. Is 3,000 rand cash maintenance fair for a 15-year-old child if the father is a doctor, I presume a medical doctor? Now, your guess is as good as mine. Child maintenance is based upon the party's means. But firstly, the first amount you have to work out is the needs of the child. If the specific child costs 2,000 rand for argument's sake, I'm using a silly example here just to try to put across my case. If the minor child costs 3,000 rand or 2,000 rand per month, sorry, the child costs 2,000 rand per month, it would not make sense logically for the father to pay 3,000 rand per month, because then he's indirectly maintaining, the mother, and there's no legal obligation for him to maintain the mother. If the child costs 10,000 rand per month and the mother earns half the father's salary, it does not make sense for the father to pay 5,000 rand maintenance. He should be paying 2/3, not a half. 2/3, much more than half. So where do we work from? We work from the cost of the minor child. Same with taxes. You first determine what your income is, then you work out your expenditure, and then from there we work further, and then we can determine what amount of tax you must pay. Exactly the same with child maintenance. So if somebody consults with me, the first question I will ask you, and where we're working from, is what does the child cost? So if the child costs 3,000 rand per month, and then obviously for the father to pay, despite him being a doctor, to pay 3,000 rand per month will obviously not make sense, because he is paying for 100% of the minor child expenditure, unless the mother is earning nothing, she's earning zero. So in answering your question, it will all depend upon the factors of the matter. So if the child costs more than 3,000 rand per month, and based upon your income and comparing to the father's income, his contribution of 3,000 rand per month is too little, then obviously it will be too little. But I would always want clients to apply their minds to these type of matters, to apply logic and look at the matter holistically and logically. Therefore, if the child costs 20,000 rand per month and is contributing 3,000 rand per month, obviously it's too little. So I cannot answer the specific question because I do not know what the child costs and do not know what the parents are earning, but that's a general principle to apply under these circumstances. So question number 12. When do I go to the domestic violence court? Must I go to the police first? Okay, domestic violence court. A specialist court dealing with domestic violence, abuse, emotional abuse, psychological abuse, harassment, stalking, economical abuse, etc. That's a court. But it's domestic in the sense of there should be some type of a relationship between the parties. For example, mother, father, son and daughter, or uncle and aunt. It must be a family relationship between the parties. So a brother can take a sister can take the brother, a mother can take the daughter can take the father, and so on. At the same time, if the parties were involved in a relationship, for example, ex-lovers, girlfriend, boyfriend, and so on, that was also a domestic relationship they were involved in, and they can also take each other to the domestic violence court. As compared to, for argument's sake, if I have a problem with a third party, with a co-worker who's swearing at me, that is not a domestic relationship, that's a professional relationship, and they have to go to the harassment court, a total different court. So remember, domestic violence, basically, I like to play family or partners or lovers and so on. I like to, it's easier to work out which, if the court can deal with a specific case. So when do I go to the domestic violence court? Yes, firstly, if you are a victim of domestic violence, and at the same time, the other party, or you're in a domestic relationship with the other party, either family member or you're in a relationship with the other party. The second question is, must I go to the police first? No, you do not have to go to the police first. Go to the police if it's urgent, if the person is now maybe assaulting you or done something bad the evening. Go to the police to lay a complaint. It's very good because you can, you have some evidence and some proof that I was assaulted and that I went to the police, so there won't be any arguments later on saying, why did you not go to the police? I did go. I did lay a complaint because it was serious. What many times happens is someone will say, I've been a victim of domestic violence for many years, and other attorney, the lawyer, the other side will ask the complainant, the person who was a victim, but ma'am or sir, but let's use ma'am for now, have you ever approached the police station or the courts, or have you done anything in the past? No, I haven't. But so, ma'am, clearly if you were a victim, you would have done something about that. So do something about it. You should. So that's question number 12. Question number 13. My child does not want to visit the father. Can I withhold contact? There is no, I think not, there's no court order in place. Okay. Now, when it comes to care and contact matters, you'll always ask the question, is a court order in place? Number one, because a court order deals with these issues. If there's no court order in place, who decides? Until a court order is in place. Technically, the primary caregiver will have to make a decision as to what is best in the minor child, what is in the minor child's best interest, and if the other party does not agree to that, he or she must go to court, and the court will now make a final decision regarding that. First prize would be for the parents to come together and agree on what is best for the minor child and live it for the sake of the minor child. If the child does not want to visit the father, you need to be a mature adult and you have to now determine, are the child's reasons valid? If there are valid reasons, for example, the father is abusive towards a minor child, he's being bullied by the other party, we have to address it, we have to deal with that. But what generally happens is you deny the father contact to the minor child. The father goes to court, the investigation takes place, and then it comes about that the parties were being unreasonable, the mother was being unreasonable for limiting contact. So therefore, it's always advisable to get a professional on board, a social worker, to consult with the child and find out by the child, why do you not want to see go to the dad? And let this professional now maybe advise you as to whether or not they agree with the child's reasons for not going to the father. I'm a staunch believer that the minor child must have a relationship with both parents. I'm a staunch believer thereof, and I do not believe in one parent alienating another a parent from a minor child, and vice versa. I'm against that. I fight very hard in the High Court to, enforce parents' rights. At the same time, if a parent, on the other hand, is not a good influence for the minor child, I'm not there to decide upon that. Obviously, the experts are there to recommend and decide upon that. But parents, please try your best to resolve these matters out of court. There's no reason why this matter should go to court. You can resolve this matter, maybe with the assistance of a social worker and some professional. Okay, the last question number 14, and then we can deal with the other questions we have. What do you do, I presume, if the maintenance officer does not want to listen to your side? He only listens to the lawyer of my ex. So here we have a scenario where the parties are in the maintenance court, you are underrepresented, the other party has an attorney, and when you speak, the maintenance court doesn't listen to you, maintenance officer doesn't listen to you, he only listens to the other side. First answer obviously would be, if it's possible, maybe get an attorney as well, to represent you in court. Sometimes people engage in a maintenance court matter, which they're entitled to, and I believe you should, but after a while, it's obvious to the maintenance officer you do not know what you're talking about. You are arguing issues. For example, in a maintenance court matter, you're talking about affairs that the father had, or you're talking about things which are irrelevant under the circumstances. So maybe the maintenance officer is getting tired of that, and he or she is listening to the lawyer, or maybe the maintenance officer is being afraid of the attorney and giving the attorney more airtime. I do not know. So maybe it's a good idea to get an attorney on board. If you cannot afford, and which is a reality in many of these type of maintenance matters, then do a bit of research, and if the maintenance officer still does not want to listen to you, lay a formal complaint to someone in the court system, and once you appear before the maintenance magistrate, if that happens, address that before the maintenance magistrate. But maybe at the same time, write it down and mention to the court, these are my concerns, these are the things which I want to mention to the court. So it's on record. So the maintenance officer will obviously have to apply his mind to it, and if he doesn't, the maintenance magistrate will have to apply their mind to it, as opposed to you trying to verbalize it. And at the same time, maybe have an attorney or someone look at that specific document before the time, or discuss it with him or her. Find out whether or not your concerns are reasonable or are they valid. But remember, in a maintenance matter, the case gets determined based upon, in my view, simple mathematics, simple equations. The expenses of the minor child, the needs of the minor child, and the income and expenditure of the parents. Simple as such. Therefore, if you can present to the court what the minor child costs, what's reasonable under circumstances, your income and expenditure, then that should be fine on a spreadsheet, on a piece of paper. That is your case. With supporting documentation, of course. That is what you must present. not necessarily argue a lot with the maintenance officer. If the maintenance officer mentions to you that, man, this is not reasonable, it's not, this, for example, the pony is not reasonable, then you mention, you know what, all our other children had ponies. The father also had a pony when he was younger. He can afford it, and it's been the norm in our family. That's why the minor child needs to have a pony, or the father must contribute towards that. Have an answer for every expense which you have, and which you are claiming from the other party. I hope that answered that specific question from our Zoom pre-registrants. Thank you very much for doing that. I have another question on the Facebook Live. I'll deal with that now. Question number 7, I see on the Zoom, on the other Zoom, another one in front of my screen. It goes as follows: regarding the passport, must the father be present? Oh, it's a follow-up on that specific regard over there. The father says that if I go to the Department of Home Affairs and apply for a passport without his consent, he will lay a complaint of fraud against me. Can he do that? Okay, I see what's happening over here. So basically, the mother wants to apply for a passport for the minor child. The father says, you know, I'm not consenting to that, but if you do that, I will lay a complaint of fraud against you. Can he do that? I do not think he can necessarily lay a complaint of fraud against him, because you will obviously advise the children. Sorry, will advise the Department of Home Affairs that the father is not giving consent, and whatever the case may be. And here already it was mentioned that the father does not give consent, will not give consent. I would advise you to avoid all problems and avoid all issues. Go ahead one time to the High Court, obtain a court order stipulating that the father's consent should be dispensed with, and that's it. I also heard from another client of mine that she approached the Children's Court for such an order, but I do not know if they do that. It depends on the Pacific Children's Court, because I have dealt with previous issues whereby the Children's Court referred matters to us to assist them because they felt that they cannot deal with these type of matters. So I speak under correction. So you can just verify from the Children's Court first, are they willing to assist people when it comes to passport consent? And if they are, wonderful. If not, you have to approach the High Court. I have another question over here. Yes, that's all the question regarding the 3,000 Rand cash maintenance. Where was that? Yes, sorry. That was question number 10 from KwaZulu Natal. The minor child cost 10,000 Rand per month. Okay, that's some data we have over here. Now, I would say 3,000 Rand per month is too little. If the child costs 10,000 Rand per month and the father is only willing to pay 3,000 per month and is a medical doctor, obviously 3,000 Rand would be too little. If you and the father earn the same amount of money, then obviously 5,000 makes sense, but that's obviously not the case. So, far too little regarding that. I have a question on the Facebook Live. Let me deal with that quickly. When you apply for maintenance or of your child, will the court take into consideration that there is already a maintenance plan in place for another child? Furthermore, if my child's expenses are more than the other child due to my child being 13 and the other child being 2 years old, would my 13-year-old get out less because the current maintenance order for the 2-year-old takes up most of the income, and only now a small amount is left for the 13-year-old? Very interesting question. Basically, the principle which applies here is one child should not get preference over another child. That's very important, and no court will make such an order necessary. So, if one child, of course, is attending school and requires a certain amount of school fees, the court cannot now stipulate, this child is older, therefore he must get the school fees and the other child must suffer because he's young, or the other child will have to get less because the child is only attending daycare, and therefore that specific child does not require the specific maintenance. So all the information will have to be presented to the court. I can maybe put it that way. The information that he is currently paying for the 13-year-old and has to pay for the 2-year-old, whatever the case may be, and the court will, based upon that, have to make a decision what is fair and just under the circumstances with the application before them. And the father in this specific case will have to now explain to the court why is he paying so much maintenance for the 13-year-old, or why is he paying so much maintenance for the 12-year-old, or why does he want to pay so much maintenance for either child. And the court will ultimately have to make a decision what is fair. Now, that's the question, fair. Now, obviously, if you preference one child over another child, that's not preferent. But because there's a second child in the mix, of course, both children will have to get less than they would have gotten had there only been one child. So I think that basically answers that question. I do not want to give you an answer which might come across that one child will be preferent over another child. No, the law doesn't work that way. The same way if a child was born in wedlock and without a wedlock, still the same way. With a child that's born within a marriage, for example, the husband is married to his wife, they have a few kids together, he does something and he makes another lady pregnant while he's married to his wife, does that child also, will that child now get less maintenance, be cared for less under the circumstances? Still, the court will have to make a fair decision on what is best for all the minor children involved. But obviously, his current kids will now, unfortunately, will have to get now less in order to pay maintenance for the new child. And that's only fair under the circumstances, as long as we do not preference one child over another child. I hope it answers your specific question on the Facebook Live. Thank you for that. If I have not, please feel free to pose an additional question on that. Okay, on the Facebook Live, can the other parent withhold a special needs child's right to access therapists, I presume, as the other parent's consent is needed? However, the other parent is aware that the child needs speech therapy, but chooses the cheapest therapist instead of one with real experience and a lecture on this. Why is it compulsory for both parents to sign consent when one's ego needs to be stroked? He never played a part in the child's therapies before, as he was all important and working. So let me understand the dynamics over here. The child needs to go for therapy, but one parent does not want to give consent. And basically the question over here is, why should both parents give consent? Yes, and it makes logical sense. If both parents are the guardians of the minor child, they both need to give consent to the minor child obtaining therapy and those type of procedures, because they're the parents, they need to be consented regarding that. If you feel under these circumstances that the one parent's consent should not be given because he or she always plays hardball and make it difficult, then you need to approach the court, and the court will have to obviously limit that specific parent's consent. But I know many therapists, they refuse, they will not deal with any therapy regarding a minor child unless both parents' consent is obtained. So I can only answer you, the general answer would be that both parents are guardians and both of them, their consent is required. The same way, I'm not applying to the scenario. Let's say the child is being cared for by the mother, and here all of a sudden the father takes a minor child for a medical procedure, or the father takes a minor child to a psychiatrist or psychologist. Obviously the mother will say, but my consent should have been required because I'm the parent of the child. Now, unfortunately, the court doesn't want to get involved in the politics between the parents, the issues between the parents. But if one parent believes that the other parent is being unfair and unreasonable, the court, as upper guardian of all minor children, can get involved and rule and override the rights of any other parent. So I hope that answers your specific question over there. You need an order to stipulate that these are now your rights going forward, considering all the historical background of the matter. Okay, let us go from the start over here. So, ladies and gentlemen, I see we have no further questions on the Zoom and on the Facebook Live. We dealt with quite a lot of questions today on the Zoom and the Facebook Live. Thank you very much for your time. Unless I see anything else, I will obviously have to end this video in the next few moments' time. We are having our last webinar next week and Saturday, the same time. That will be your last opportunity for the specific series to register for these webinars and obviously to partake in them as well, and obviously pose whatever questions you may have. So feel free to do so, and I'm looking forward to see you online next week. Thank you very much for your time, and I hope you have a lovely weekend further.